So good afternoon, everybody. I would like to start the session now. My name is Christine Hurst, Deputy Head of the Democratization Department at ODIHR, and I have great pleasure to welcome you all this afternoon. Dear delegations, dear participants. The session this afternoon is Rule of Law, covering the right to a fair trial, independence of the judiciary, and democratic lawmaking. The session will focus on the right to a fair trial and good lawmaking as two essential aspects of a democratic society. It will address major challenges to the independence of the judiciary, namely those related to the appointment, selection, and training of judges, the procedural independence of prosecutors, and the independence of lawyers in the OSCE region. The session will also discuss how to ensure a transparent, open and inclusive lawmaking process which results in effective and human rights compliant legislation. The session will discuss practical solutions to identified shortcomings and facilitate the sharing of good practices in these areas. Among the questions which we would like to discuss this afternoon are: how can participating states address challenges related to judicial training, selection and appointment, and how do these impact gender equality and minorities? What specific measures do OSCE participating states adopt to ensure that their legislative processes are transparent, inclusive and open? And how do OSCE participating states ensure that all relevant stakeholders are properly consulted on draft policies and legislation, and that parliaments properly scrutinize these drafts? The list is still open, so a wee reminder that the speakers list is at the back of the head table here, if anybody else would like to sign up. We have not yet reached the limit of 50 participants. I would like to remind that speakers can only take the floor in the capacity in which they are registered, and only entities registered on the speakers list can be represented. I would also remind you that live streaming of the 27 HDIM is available, and filming with cameras and video cameras is only permitted by accredited journalists. No other audiovisual recordings should be undertaken without the explicit permission of the individuals being filmed. I would also like to invite participants to the ODIHR reception on the margins of HDIM, which will take place tonight at 8 o'clock in the evening at Villa Foxal. Participants can collect their invitations in the delegation's pigeonholes and on the ODIHR publications table. The buses will leave at 7:45, 7:45 from here. And for public transport options, please refer to the notice wall in the foyer. So after these more administrative points, I have the great pleasure to introduce our speaker, Mr. Niels Engstad. Since 2000, Niels Engstad has been a judge at the Hålogaland Court of Appeal, Norway, a court with general jurisdiction and composed of generalist judges. Engstad is also the chairman of the Finnmark Land Tribunal, a special court within the Norwegian court system set up as part of the process for clarification of land rights for the Sami people and others in Finnmark County, the northernmost county in Norway. Engstad has been a member of the Consultative Council of European Judges since 2004, elected president of the council from 1st of January 2016, and the president of the Norwegian Association of Judges. Prior to his appointment as a judge in 2000, Engstad worked as a private practicing lawyer. He has also been the head of department at the Norwegian Polar Institute, state secretary at the Norwegian Ministry of Justice, and an advisor to the Norwegian Minister of Foreign Affairs. So, with no more ado, I would like to hand the floor to Mr. Engstad. Thank you.
Well, Madam Chair, thank you. Ladies and gentlemen, I've been taking a look at the audience, and I must say you look great from here. I'm really happy to be here, and I must thank the organizers so much for inviting me to take part in this event, which is the largest annual human rights conference in Europe. And it is, as always, a great pleasure returning to this wonderful city of Warsaw. As the moderator said, I am here in my capacity as the president of the Council of Europe's Consultative Council of European Judges, which is an advisory body within the Council of Europe system set up by the Committee of Ministers in the year 2000 in order to promote the independence, the impartiality, the competences of judges in the member states, the 47 member states of the Council of Europe. And as you know, these are vital elements of the rule of law, judicial independence and impartiality. And today I'm here to share with you some observations on the rule of law. Now, there are probably as many definitions of the rule of law in political and legal science as there are definitions of democracy. There are numerous definitions. But there are two requirements that cannot be ignored in any attempt to define the rule of law, and that is the principle of legality and the requirement for access to independent courts. Now, the principle of legality involves the ideal that the law must be accessible and, so far as possible, intelligible, clear, and predictable. However, even accessible, clear, and predictable laws adopted by democratic procedure can be bad, can be harmful. Laws can be evil, as Professor Brian Tamanaha has put it. So, democracy in itself is not a guarantee for the enactment of good laws. But a good lawmaking process should always pay due regard to democracy, to the rule of law, and to the protection of human rights. Laws must conform to human rights and to international commitments. As stated by the European Court of Human Rights, laws must be compatible with the rule of law. And a good lawmaking process should also involve public participation and public consultations, especially with potentially affected parties. Consequently, also out of respect for the principle of separation of powers and for the benefit of judicial independence and judicial accountability, the judiciary should be ensured effective participation in any preparation of reform of the judiciary and the judicial system. To my mind, a good example in this respect is the process for reforming the court structure and judicial independence in Norway. For the preparation of the reform, the Norwegian government recently established an expert commission composed of 15 members, 4 of whom are active serving judges appointed after consultations with the Norwegian judiciary. A bad example is the recent vetoed bill on the Polish Supreme Court, submitted to the Parliament without any prior public consultation or participation from the Polish judiciary. put to the vote the week after its submission. Let me add, the bill was not bad only because of the lawmaking process, but also because of the content of the bill, representing a major setback for the independence of the judiciary and for the rule of law in Poland. There is no rule of law if there is no access before independent courts deciding on the legality of the government's actions against its citizens. Consequently, there is, and there must be, some kind of tension between the judiciary and the government. If there is no such tension, the judiciary is probably not doing its job. But this tension calls for institutional and other safeguards with respect to the independence of the judiciary and to the accountability mechanisms available with regard to the judiciary. Now, these safeguards, they are under attack in a number of national legal systems. They are under attack. The reports on judicial independence and judicial impartiality in member states of the Council of Europe, presented by the Consultative Council of European Judges and the Consultative Council of European Prosecutors, reveal numerous incidents showing that undue interference in judicial independence come in various forms. Now, some of them are flagrant attacks on the independence of the judiciary, while others come in more subtle ways. Time does not allow me to go into details, but let me share with you my concerns regarding the attempts to politicize judiciaries and prosecution authorities. Independent judges are essential for the rule of law, but so are independent prosecutors. As stated by the European Court of Human Rights, both the courts and the investigating authorities must remain free from political pressure. Must remain free from political pressure. And this is also essential for the public trust in justice. Now, for sure, there are challenges to the public trust in the judiciary in many countries. In some, corruption is widespread, also affecting the judiciary. Corruption in any form must be combated. In some jurisdictions, excessive length of court proceedings remain a chronic problem. We know there are shortcomings in national judicial systems that should be remedied, not least in the interest of the public trust in the judiciary. However, you don't have to love your judge. No, judges are not there to be loved. Judges are there to uphold the rule of law. Judges are there to uphold democracy. Judges are there to uphold human rights, and to do so independently, and to do so in an accountable way. And therefore, shortcomings in a domestic judicial system can never be a valid argument for politicization or even for a full governmental takeover of the judiciary. And why so? Because politicization and political pressure on judiciaries and on prosecution authorities may cause self-censorship and have a chilling effect on judicial independence and impartiality. Politicization of courts and prosecution authorities is likely to be followed by widespread negative effects on media freedom, on the freedom of expression, on the freedom of lawyers, on the freedom of the work for human rights activists and human rights NGOs. Now we have seen this happen. We have seen this happen in our time. We have seen this happen in democracies, where the government is based on a majority in the parliament, and the government has a strong ambition to remain in power for a long time. We have seen it. In the worst case, such undue influence and interference in judicial independence will lead to the termination of judicial independence and the termination of the rule of law. Now, this is well known. This is well known. We have seen it happen, time after time. This is well known, and therefore, people march in the streets when judicial independence is under attack, because an attack on judicial independence is also an attack on the rule of law. It is an attack on democracy. It is an attack on fundamental freedoms. And at the end of the day, it is for the people, it is for the civil society, and it is for the citizens of any nation to choose which path to be followed. It is for the civil society to choose the path to be followed. And therefore, ladies and gentlemen, when needed, people should keep on marching. Keep on marching. Thank you for your attention.
Thank you very much, Mr. Engstad. I think that was a very useful and passionate introduction to the important questions which we have to discuss in this session. So we still have space on the speakers list, and because we have a little bit more luxury of time than some previous working sessions, we are allocating 2.5 minutes to each speaker. Before we start, if I could just remind participants that when you first speak, please introduce yourself, your name and your organization, or the delegation or institution that you represent. Please keep your comments brief and to the point, preferably listing first recommendations so that we are sure to get those. Criticism is welcome, but should always be constructive. Participants are encouraged not to read lengthy prepared statements, and prepared statements can be submitted to the Document Distribution Centre, which will distribute them to all participants. So, to begin, firstly, I have Lithuania on behalf of the EU, which is followed by Religious Society Path of the Guru Jara. So, if I can invite Lithuania to take the floor. Thank you.
Madam Moderator, I'm honored to speak on behalf of the European Union, and this statement is aligned by Montenegro, Bosnia and Herzegovina, and Norway. The EU reaffirms that the human rights, rule of law, and democracy are interlinked and mutually reinforcing, and belong to the universal core values and principles. Independence of the judiciary and the right to a fair trial constitute inseparable part thereof. As our introducer rightly mentioned, the years 2016 and 2017 saw unprecedented actions of some governments in undermining the judiciary and openly challenging the principle of separation of powers. The EU remains concerned with the ongoing politicized trials in the Russian Federation, which call into question the independence of the judicial system. The political character of trials and sentences are best illustrated by the criminal cases brought against the Ukrainian citizens, such as Sentsov, Kolchenko, Umerov, and the recent case by Deputy Chair of the Crimean Tatar Mejlis, Chigos, and many others who oppose the illegal annexation of Crimea. Another source of concern is a decision by the Constitutional Court of the Russian Federation to undermine the supremacy of the judgments by the European Court of Human Rights, which clearly infringes upon Russia's obligations under the European Convention on Human Rights. In light of the above, we once again call on the Russian Federation to guarantee the independence of the judiciary and ensure full compliance with the international standards and Russia's international commitments. The EU views with concern the growing number of arrested journalists, human rights activists, and members of the opposition in Turkey. Turkey has the right to bring the individual perpetrators of the coup d'etat to justice. However, all those detained and dismissed in the aftermath of the July 2016 coup d'etat should be entitled to a fair trial and a swift and effective judicial remedy, in compliance with the rule of law and independence of the judiciary. The EU also closely follows the constitutional reform in Turkey. The EU reiterates that it's ready and willing to continue to work with a stable, economically vibrant, and democratic Turkey. Let me conclude with the following recommendations on this subject. The OSCE participating states should ensure full respect for the principles of separation of powers and the independence of judiciary, in compliance with international standards and their international commitments. Evaluation and accountability procedures for judges should not be used as a means to influence the independence of their decisions. Access to justice and equal representation should be ensured to persons belonging to all groups of the society. The entire text will be distributed in written form. I thank you, Madam Chair.
Thank you very much. So next we have the Religious Society Path of Guru Jara, followed by Human Rights Vision. If I can invite the Religious Society to take the floor.
Dear Ms. Moderator, my name is Dr. Filip Manek and I'm speaking on behalf of Path of Guru Jara from Czech Republic. We are reacting on OSCE judicial standard, which would be carried out in non-discriminatory manner, actively encourages as well as candidates for diverse backgrounds, including minorities. We welcome the judges, as any other public person could be LGBT or members of minor religions, but we are afraid that in reality, prejudices in Czechia expose them to strong pressure. Regarding to our field of interest, for example, this year Czech Minister of Justice, Dr. Pelikan, supported activities of religious society yoga in daily life. However, only when they were presented as materialist even and publicly concealed their master, Swami Maheshwarananda. Could he openly confess faith in this society? Their Swami was doubtfully charged in European Union for sexual harassment some years ago. Also, Czech Anti-Cult warned public against their group perils. We have similar experience when chairman of regional court Dr. Gargulak and judge Dr. Buchkova denied through court spokesman in 2016 any previous religious connection to our group after prefabricated accusation and illegal sentence of spiritual leader Jaroslav Dobeš and Barbora Plašková. Despite the facts that they both were provably active mentors of Guru Jara's teaching for years. Their denial might be a result of unproven slandering accusation in media about sexual exploitation in our group, fueled by claims of anti-cult movement ongoing since 2011. We stand for safe coming out of judges or any public person, its own sexual orientation or religious affiliation without fear of becoming target of prejudices or hate crimes in Czech Republic. Thank you for your attention.
Thank you very much. So next we have Human Rights Vision, followed by the Russian Federation. If I could invite Human Rights Vision to take the floor. Thank you.
Thank you, Madam Chair. My name is Victoria Nadezhdina. I represent Public Organization on Human Rights Protection, Human Rights Vision. In Tajikistan, there was a practice whereby an investigating officer provided a judge with all procedural documents already filled out, starting from the arrest warrant all the way through conviction. This is done in electronic format using a USB stick, and the role of the judge is to rubber stamp the documents and announce the predetermined decisions. During bail hearings, defendants would show the judge their torture wounds, tell the judge where they were subjected to torture and by whom, but the judge would neither grant relief nor investigate the allegation of torture. There is a sheer absence of due process and justice. Evidence presented to prove that an accused is not guilty is prohibited. The system of justice is highly corrupted. The cruelest measures of punishment are applied towards political prisoners. All the decisions of court in relation to political prisoners are taken under total control and pressure of State Committee of National Security and other law enforcement authorities. Consequently, Buzurgmehar Yorov, Mahmad Ali Haid, and other members of Islamic Revival Party of Tajikistan stay illegally imprisoned till the moment. The courts in Tajikistan are not independent and depend directly on executive power. The decision to appoint a judge or remove from office is taken by the president. In case of improper or unreasonable removal from office, the decision cannot be subject to appeal. Summing up, on behalf of Human Rights Vision Foundation, we appeal to the authorities of Tajikistan to fulfill their obligation in the sphere of human rights for uniform fair trials according to international human rights acts. To eliminate government control over the activity of judges, it's necessary to provide the public, both media and citizens, access to court proceedings. These proceedings have to take place in the courthouses, not in pretrial detention centers or temporary detention centers. We also appeal to the international community to pay closer attention to illegal arrests and unlawful detention in Tajikistan, to react urgently to violations of the right to a fair trial. The full version of our report will be available on the website. Thank you.
Thank you. So next we have the Russian Federation, followed by the United States of America. If I can invite the Russian Federation to take the floor.
Madam Moderator, dear experts, the most important guarantee for human rights is the right of defendants to a fair trial, and that, of course, includes access to justice, ensuring the adversarial principle, equality of procedural rights, the right not to give witness against oneself, and also the right to execution of the definitive judicial decision. Now, these principles are at the very heart of the criminal procedure in the Russian Federation. But unfortunately, in the OSCE area, there are quite a few cases of open defiance of the principles of rule of law and the norms of international law. And in this case, of course, there is no real access to justice. An obvious case of this open defiance and rejection of human rights is the state coup d'etat in Ukraine. And those who came to power as a result not only started massive repression of dissidents, including cases of persecution and assassination, but they also handed down an absolutely illegitimate, unconstitutional order to use force against people in the southeast of the country, thereby instigating bloodletting through a civil war. This is a so-called anti-terrorist operation in Donetsk and Lugansk, as a result of which peaceful people are dying in their own homes. And in the secret prisons of the security service, many cases of torture have been revealed. Apart from that, Ukraine is the only participating state of the OECD where right-wing radicals have been incorporated into the forces of law and order. The presence of right-wing radicals in the Azov regiment, which has been merged with the National Guard, was explained by the deputy commander Yaroslav Slodar as based on interest in history and a different view of the National Socialist movement in Germany. Another example, of course, is the Guantanamo prison, where people are being held in an absolute legal vacuum for years, with no charge and subject to torture and severe treatment. And then we are very much afraid of the use of court verdicts in American and British courts, which use those courts for illegal hunting of Russian citizens right around the world. We have quite a few compatriots who have become victims of this hunt, like the entrepreneur Viktor But, the programmer Roman Seleznev, and the Pilot Konstantineshenko. We also remain incredulous in the face of not infrequent appeals by several Western partners to the executive authorities of other states to influence decisions of independent judicial bodies in certain high-profile cases, and these appeals sometimes come even before the case has been tried. And then there are these international courts, which can be very bad for people's health or even their lives. The International Court on the former Yugoslavia, for instance, where the procedure is not equal at all. As for the International Criminal Court, we voted in favor its creation because we felt that it would be really an independent court and would not be politically engaged, but that is not the case. We are convinced that the rule of law and the issue of access to justice should remain at the center of the OSCE's attention as a particularly important aspect of cooperation among the organization's participating states. The full text will be distributed subsequently. Thank you for your attention.
We next have the United States of America, followed by Human Rights Without Frontiers. If I could invite the United States of America to take the floor.
Thank you. Russia's judiciary has been used to imprison people for political reasons. There are at least 120 people imprisoned at this time, and a climate of impunity for murder of whistleblowers and journalists. In Russian-occupied Crimea, we call for the release of Zhigos, Umerov, Baluk, Sentsov, Kolchenko, Kostanyenko, Semena, and Zaytulayev, and others. In Turkey, over 4,000 judges and prosecutors lost their job. We call on the government to suspend the state of emergency, ensure fair, transparent, and timely trials, and to release Pastor Andrew Brunson, who was wrongfully imprisoned. Azerbaijan should release all 140 prisoners of conscience, including former presidential candidate Mamadov. Harassment of defense attorneys should cease. We commend Armenia's consultations on its draft judicial code. In Georgia, more judicial independence is critical for investment, economic growth, and stability. We urge Poland to ensure that any judicial reform respects judicial independence and separation of powers. Peaceful demonstrations in Romania demonstrated people's desire for good governance, including a stronger judiciary and the rule of law. We encourage Serbia to address judicial independence and pretrial detention. Despite the highest level promise, authorities have not brought to justice those responsible for the 1999 murders of 3 Americans, the Batici brothers. We support Macedonia's special prosecutor's investigation of abuse of power and encourage reforms for judicial independence. We urge Albania to continue its constitutional reforms. Tajikistan targets defense lawyers, including Yorov and Makhanov. Turkmenistan has offered no excuse for withholding all information on all who have disappeared into the prison system, including former OSCE Ambassador Berdiev. It should provide international prison access. Finally, we note Uzbekistan's release of several prisoners of concern. We urge Uzbekistan to facilitate the return of international NGOs to support justice sector reforms. Thank you, Madam Moderator.
Thank you. So next we have Human Rights Without Frontiers, followed by the Institute for European Studies. If I can invite Human Rights Without Frontiers to take the floor.
Thank you, Mrs. Moderator. My name is Willy Fautrey, Director of Human Rights Without Frontiers. 2 Czech citizens, Barbora Plashkova and Jaroslav Dobes, have been respectively detained in the Immigration Detention Center of Bagong Diwa in the Philippines since April and May 2015 on the grounds that their passports were no longer valid. Both of them had been living and working for years as yoga teachers in the Philippines, and each of them has a child born in the country. In April 2015, Barbara Plashkova went to the Czech consulate in Manila to prolong the validity of her passport, but she was denied a new one and she was sent to the Immigration Detention Center where she still is. In May of the same year, it was the turn of Jaroslav Dobes. Both Czech citizens were hereby left undocumented by the embassy in the Philippines. In pride, the authorities requested and obtained from Interpol the issuance of an international arrest warrant against Jaroslav Dobes and Barbara Plashkova because they had been sentenced to a prison term by a lower court in the Czech Republic. But their sentence was totally cancelled 6 months later. A new trial should have been launched, but since May 2015 there hasn't been any new trial. and both citizens are still detained in the Philippines. So what solution to such a situation? We recommend the Czech authorities to respect the presumption of innocence of Jaroslav Dobeš and Barbora Plašková, as the prison sentence released by the regional court in Brno in 2014 was totally cancelled by the High Court of Olomouc 1 year later. That they communicate the content of the Interpol arrest warrants against both Czech citizens to their lawyers, as both of them have never been among the most wanted persons of Interpol website. That they grant them new passports, even if limited to travels between the Philippines and the Czech Republic, in order to put an end to their status of undocumented persons and to their detention in Manila. That they agree with the Filipino authorities that they can release them, but that they will have to regularly report to the police station close to their residence, and finally, that they maintain this proposed administrative situation as long as there is no new legal or judicial development in their case in the Czech Republic. Thank you.
Thank you. So next we have the Institute of European Studies, followed by Uzbekistan. I invite the Institute of European Studies to take the floor.
Важнейшим
The most important principle in building a democratic society is ensuring access to justice, to a fair and independent trial, regardless of the ethnic origin of someone seeking justice. Allow me to give you two examples of how in Latvia, a country where I live, this important principle is being violated. The first example is that in Latvia, 40% of the Russian population does not have right to citizenship and are non-citizens. I am a non-citizen. I'm a professor, I'm a doctor, but I'm not a citizen. That's been taken from me. I do not have the possibility to have an influence on the judicial system. First of all, you have to be elected a representative, and then they elect judges who take decision. Now, 3 years ago, we put forward an initiative for a referendum to give all citizens the rights of, no, non-citizens the rights of citizens. The first stage was it was stopped at the first stage without any fundamental explanation. We took that decision to the Supreme Court, which took to the decision that it was fair, that the first instance had the right decision, made the right decision. And the decision made against us was unfair, and that we did not have the right to appeal that decision to the courts. Recently, and this is the second case, a representative in the parliament, Edmund Schnorrer, announced that all Russians were, and he used a very unpleasant term. He used a term which was used by a well-known National Socialist, and we complained to the public prosecutor, and we were denied the right to pursue or to complain about this ethnic insult. Now, I've heard people say that the American tanks in the country can be used against the Russians. Now, that's a point of view I've expressed in the past, but I was prosecuted for that and had to stand before a court as a result of it. Again, the decision was unfair. I was taken to court because I'm an ethnic Russian. I was only addressing the political illegitimacy of this kind of decision, whereas the representative insulted all ethnic Russians. So I think it's important for the OSCE to look into the fair representation of all ethnic groups. Thank you.
Thank you. So next we have the delegation of Uzbekistan, followed by the Moscow City Chamber of Advocates. If I can invite the delegation of Uzbekistan to take the floor.
Thank you, Madam Moderator. Ladies and gentlemen, the Republic of Uzbekistan is making unflagging efforts to ensure and strengthen the independence of the judiciary. We adopted a strategy of action in February of this year, which covers 5 different thrusts for the next 5 years. And one of those is to ensure absolute independence of the judiciary, make sure that human rights are guaranteed. That is one of the high priorities in this strategy. Now, given the current situation in the country, some significant changes have been introduced into the Constitution and the basic text, most of them aimed precisely at strengthening the independence of the judiciary. And I would like to draw your attention to the following points. First, for a bottom-up improvement of the system, the training of a highly qualified group of judges, it has been decided to ensure full independence also of the Association of Judges. They are the ones who review candidacies for judgeships and who give recommendations as to who should be appointed to senior levels within the judiciary. There can be no interference in the actions of the judiciary. What's also important, of course, is the professional training of judges, their qualifications, and also a good system for evaluation of their work. Now, the Council of Judges has 21 members. The President is appointed by the Senate, and the others are appointed by the head of state. Furthermore, 11 of them, that is a majority, are chosen from among judges, whereas the other 10 come from the forces of law and order, from civil society, and from among highly qualified legal professionals. Second, the terms of office of judges have been reviewed. Previously, judges were elected or selected for 5 years, and for every 5 years, they had to be reappointed or reselected. Now they are initially selected for 5 years, and then they have a 10-year term of office, and the third term of office runs until retirement. And the same individual cannot have more than 2 terms of office as the president of a court. Those terms of office are 5 years. So once they have gone through a 10-year term, they go back to being ordinary judges, the only exception being the president of the Supreme Court. Now, all of this is not only aims at guaranteeing the independence of the judiciary as a whole, but it also is aimed at improving the qualifications of those working for it. Thank you.
Much. So next we have the Moscow City Chamber of Advocates, followed by the All-Ukrainian European Foundation, the League of Law. So if I can invite the Moscow City Chamber of Advocates to take the floor.
Thank you very much. Respected colleagues, Nikolai Polozov, and I'm a Russian lawyer. I work on issues related to political prisoners in Russia. And, of course, the independence of courts in Russia is something that we can't really say is existing at the moment. There's a clear influence of the vertical power structure, and the courts, the judges are not independent and are required to make certain decisions by the executive powers. Crimea has been recognized as a territory of Ukraine, temporarily occupied by Russia over the last 2 years, according to the UN. I've represented some Ukrainian political prisoners, and this is a very important issue. Achami Chigoza is the president of the Mezhliv, the Tatar assembly, who was sentenced to 8 years imprisonment for events that took place on the territory of Crimea before the Russian occupation, before the referendum. Of course, there was no free and independent court proceedings. Firstly, the individual was effectively condemned for acts that took place on the territory of Ukraine. Secondly, the trial itself didn't take place with direct participation of the accused. The accused only attended the proceedings, which lasted over a year, by video. So there was clear negligence in terms of legal procedure here. The Russian Federation, furthermore, has limited citizens' access to participation in this proceeding, clearly selecting who can participate and who can't. Alongside this, there are obviously clear violations of the Convention on Elimination of All Forms of Racial Discrimination. The defendant was allegedly participating in certain protest activities. In light of the proceedings, in light of the regulations here, I would like to recommend that there be reflection on how to learn from the experience of such trials and make sure that international standards are followed for all such trials. Thank you.
Very much. So now we have the All Ukrainian European Foundation, the League of Law, followed by Ukraine. If I can invite the League of Law to take the floor.
Dear Chair, thank you. My name is Oksana Maiba, All Ukrainian European Foundation, the League of Law Ukraine. One of the greatest achievements in the field of justice in Ukraine was adoption of amendments to the Constitution in the field of justice and the law of Ukraine on the judiciary and the status of judges. The above amendments should have provided new principles for the functioning of the higher authorities of the judiciary, greater accountability of judges, and new transparent procedure for the appointment, recertification, and dismissal of judges. Throughout the year, the High Qualification Commission of Judges held a competition for judges to a newly reformed Supreme Court of Ukraine. Out of 120 selected candidates, 30 have the negative opinion of the Public Council of Integrity, established and acting in the order to assist the Commission in evaluating professional ethics and integrity of the candidates. Thus, every fourth forthcoming judge of the Supreme Court used to violate human rights, for example, limitation of the right to peaceful assembly, has made politically motivated decision, for example, conviction of Lutsenko, or cannot explain his or her own assets. In addition, the pace of reform of the judiciary considered to be too slow, as the recertification of judges in local and court of appeals has not yet begun. Therefore, the level of public trust in the courts remains low, namely only 14% of citizens. Another important issue is ensuring of independence of the judiciary in Ukraine. This refers, first of all, to the independence of judges. According to official statistics, the share of acquittals in 2016 amounted to 1.1%. In comparison, this number is from 15 to 30% in the countries of Western Europe. Out of these, about one-third were cancelled by the courts of appeal on formal grounds as a result of prosecution's appeal. There are occasions when the prosecution initiates criminal cases against judges who gave acquittals, charging them for knowingly unlawful decision, which is quite serious challenge to independence of judges and to some extent explains such low percentage of acquittals. Second of all, we underline the importance of ensuring independence of professional lawyers that provide free legal aid. One of the major steps forward was establishing of the regional centers for the provision of free legal aid in 2013 that provide free lawyers to the person arrested under administrative or criminal procedures when they are unable to invite a defender themselves. However, today law enforcing agencies and courts have developed the mechanism of elimination of the lawyer chosen by a defendant through appointment and imposing a lawyer from regional center against his will, especially for exercising separate procedural actions. A lawyer from the center is in fact familiar with the case to the very limited extent and may not be aware of important facts due to limited timing. However, he participates in hearing of such important issues as reasonability for extending of arrest. Such cases are not rare, which makes participation of defender in such hearings formal. Thus, despite the fact of taking some positive steps towards judicial reform and implementation of good practices in the field of justice, yet the major principles of work in judiciary have not changed, which results in such low percentage of public trust. Therefore, we and urge the Ukrainian authorities to ensure qualitative implementation of judiciary reform within reasonable time with obligatory consideration of conclusion of the Public Council of Integrity, to ensure independence of judges from for giving acquittals, and just one second, and to provide guarantees of independence of the system of free legal aid from the influence of any state authorities, and ensure exercising of the right of the person to free choice of the defendant at all stages of trial. Thank you so much.
Thank you. So now we have Ukraine, followed by Crim SOS. If I can invite Ukraine to take the floor.
Good afternoon. My name is Sergei Koziko. I am a chairman of the High Qualification Commission of Judges of Ukraine. Ukrainian society shows strong demand for the efficient, accessible, transparent, and modern justice. The main aspect of the constitutional reform in the sphere of justice is to strengthen the independence of judges in Ukraine. Political influence of the president and parliament on the decisions of appointment and dismissal of judges has been eliminated. All such decisions are now approved by the main bodies of the judiciary, the High Qualification Commission of Judges and High Council of Judiciary. The recent amendments to the Ukrainian legislation provided for the leading role of the Supreme Court in the judiciary on and decisive influence to the whole system of judiciary. It is the first time in the history of Ukraine when the open and transparent competition has been provided for the Supreme Court. It was the first time when representatives, not only judges, but also advocates and professors at law took part in the competition. At the beginning of the competition, we had more than 1,400 of candidates for 120 vacancies. The results of the exam stages, as well as all steps of the competitions, are published on our website. All dossiers of candidates are also published. All interviews with candidates were streamed on YouTube. Videos are available for watching. We also use information provided to us by National Anti-Corruption Bureau and National Agency for Prevention of Corruption. We have another unique experience during the competition. The Public Council of Integrity consisted from 20 representatives of NGOs, took active participation, preparing opinions on candidates, asking them questions, and taking part in decision. Approving final decision, the Commission reviewed 126 negative opinions by the Public Integrity Council. 51 candidates who received negative opinions from PIC stopped participating in the competition before ranking was formed. In general, 80% of those who received negative opinions from PIC were not included into the final rating. Among winners, we have 46% female candidates, 54% male candidates. 76% of them are judges, 24% are advocates and academicians. The youngest candidate is 33 years only, 63 years only has the oldest one. As an advocate and professor at law, I can confirm with all respect that all the accusations from Russian delegations are absolutely groundless. We do hope that the new Supreme Court, on the basis of rule of law and a new procedural code, will influence positively on all judicial system. Thank you.
Thank you very much. So now we have Crim SOS, followed by Alternative Turkmenistan News. If I can invite Crim SOS to take the floor.
Thank you, Ms. Moderator. I'm representing Ukraine NGO working specifically on Crimea issues since 2014, since the occupation of Crimea by Russian Federation. So talking about fair trial guarantees in Crimea, first of all, I would like to follow up what has been said before by Nikolai Polozov, the lawyer who is regularly working on politically motivated cases in Crimea since 2014. And based on our work and field work, we came to the same conclusions as was said before, especially within politically motivated criminal cases, as there is no competitiveness within the judicial procedures, there is no independence of judiciary, there is no proper access of lawyers for many accused, which then result with the torture and the pressure on the accused to testify against themselves. Within the last 2 months, there have been decided another 7 sentences within politically motivated cases, 2 of them within the posts in social networks, Two of them within the so-called saboteurs case, which within the judicial procedure within the trial was not proved that it took place. One of them was against Vladimir Baluch, about which I'm sure my colleagues later will talk, who specifically work on his case, and another one against Ruslan Zaytulayev, who was sentenced to 15 years of imprisonment based on the so-called membership in so-called terrorist organization, which also was not proven in the court. So all these cases, once again, within the trial process, the guilt was not proven, and the main fair trial guarantees was violated. Altogether, in Crimea nowadays, there are 62 politically motivated criminal cases with 29 sentences which was already decided. Out of 29, 18 persons were sentenced to imprisonment on politically motivated grounds. Moreover, since in 2014, a number of common criminal cases have been reviewed by de facto authorities with the same violation of the basic guarantees, which then followed with increasing the sentences for these people. And the recent tendency is the increased use of the administrative process by de facto authorities. Within the 3 years, there have been around 200 administrative cases, and within this year, they have increased in number, as in comparison with criminal cases, there is much less attention to that cases. And with the recent example, I will end in this month, the 76 years old Crimean Tatar activist sentenced to 10 days of administrative arrest within the violation of the fair trial guarantees, which we see as a great violation of the basic human rights. Thank you.
Thank you. If I could just take this opportunity to remind participants to, when they first start speaking, to please introduce yourself with your name and your organization, delegation, or institution. That would be very helpful. Thank you. So continuing, next we have Alternative Turkmenistan News, followed by Human Rights Platform. If I could invite Alternative Turkmenistan News to take the floor.
Thank you very much. My name is Ruslan Miativ. I'm representing Alternative Turkmenistan News, independent media and human rights initiative based in the Netherlands. Ladies and gentlemen, Turkmenistan has never been famous for respecting human rights. But with the Asian Games, and they are happening at this very moment in Ashgabat, it seems that the government has lost all sense of proportion. I call upon the OSCE as the largest regional organization, as well as each individual member state present in this room, to give Turkmenistan's behavior and actions an adequate assessment regarding the following. As we speak, dozens, if not hundreds, of people are serving long prison terms in Turkmenistan for the crimes they have never committed. Today I will name just 3 of them, 3 brave men, 3 brave civil activists who simply wanted to make Turkmenistan a slightly better place to live. Sapar Mamet Nipiskuliyev received 3 years in prison on false drugs charges for reporting to independent press about poor roads and lack of drinking water in his hometown. The UN working group found his deprivation of liberty arbitrary and urged the government of Turkmenistan to release him. So did the European Union and all major international human rights organizations. However, the man is still in prison, suffering from various health risks. Another activist, Mansur Mingelov, received 22 years in prison for documenting 11 cases of torture that he and other people representing the Balochi community, the Balochi minority in Turkmenistan, that they have gone through while in detention in the Turkmen drugs police. He complained about it to the president of Turkmenistan and to the American embassy in Ashgabat, and then he was rearrested and given this long prison term. For 19 days, he was on hunger strike in prison, claiming his innocence and demanding the authorities reconsider his case. They promised, but never kept the word. Lastly, Gaspar Matalayev received 3 years in prison for monitoring labor rights of citizens during cotton harvesting campaign. By the way, as we speak, right now, tens of thousands of public sector workers in Turkmenistan, including doctors and teachers, are forced to pick cotton under threat of losing their jobs. Matalayev was arrested just 2 days after I published his report, which was titled, "They Bring People to Cotton Fields in the Back of a Truck Like Sheep for Sale." The day he was arrested, Turkmenistan's president severely reprimanded the Minister of National Security. The man was held incommunicado for over a month until his family learned that he was officially charged with fraud, bribery, and national security officers tortured him with electric shocks to confess he authored that report and that he forced him to accept the official charges. He is still in prison despite international calls for his release, including a call from the UN Human Rights Committee. I once again call on all of you and say enough, it's time to speak up. Thank you.
Thank you. So now we have Human Rights Platform, followed by Amnesty International. If I can invite Human Rights Platform to take the floor.
Спасибо. Ростислав.
Thank you, Rastislav Kasku. I'm at the civil organization Human Rights Platform of Ukraine. Ukraine has taken upon itself the commitment to carry out judicial reforms and institute trial by jury. Now, this only exists on paper. Its work does not meet the requirements of trial by jury. It doesn't work like it does in the US, for example, where there are 16 to 23 in a large jury or 6 to 12 in a small jury. Scotland 15, Austria 8. In Ukraine, the number of jurors is simply 3, accompanied by 2 judges. The main flaw is that the decision of jurors is subject to appeal, and that appeal is carried out by 3 judges who set aside jurors' verdicts on purely formal grounds. Practice has shown that a trial by jury in Ukraine has given a number of non-guilty verdicts, but all of them have been overturned on appeal. In all of these cases, where a non-guilty verdict has been returned by the jurors, the 2 professional judges held the opposite view. The judges and law enforcement agencies do not take the time to explain rights to defendants. There are egregious cases, one of which is that of Ivan Shestya in Lvov, who was denied, groundlessly denied, trial by jury, even though he's had rights to that according to the law. So we'd make the following recommendations. The authorities should make change to the procedural regulations covering the number of jurors, instituting that not less than 7 jurors be involved, stipulate where responsibility lies, and take the necessary steps. Thank you.
So next we have Amnesty International, followed by Tokmadi Media. I can invite Amnesty International to take the floor. Thank you.
Thank you, Madam Moderator. Delegates, participants, I deliver this statement on behalf of Amnesty International. Amnesty International welcomes the discussion on the independence of lawyers in the OSCE region. Using this opportunity, Amnesty International would like to draw your attention to the especially dire situation of independent lawyers in Tajikistan. To be a lawyer, and particularly a human rights lawyer, comes with unprecedented risks in present-day Tajikistan. Amnesty International's research has shown that over the last 3 years, defense lawyers who have taken up politically sensitive cases or cases related to national security and counterterrorism have faced increasing harassment, intimidation, and pressure in connection with their legitimate professional activities. In some situations, lawyers have been subjected to punitive arrest, criminal prosecution on national security-related or politically motivated charges, and sentenced to long prison terms following unfair trials. Some have had to flee the country for fear of reprisals against them or members of their families. Amnesty International is particularly concerned about the cases of lawyers Buzurgmekhiyorov, Nuruddin Makhamov, and Shukhrat Kudratov, who were sentenced to long-term imprisonment following unfair trials. Amnesty International is calling for their immediate release. For other members of the legal profession, the arbitrary arrest of these lawyers, their politically motivated prosecutions in connection with the legitimate exercise of their professional duties, and the harassment of their own defense lawyers and of their families have served as a warning and a deterrent. Furthermore, Amnesty International expresses its concern in relation to legal amendments introduced in November 2015 to the law on the legal profession, known as the Law on Advocatura. These amendments limit the independence of lawyers in Tajikistan. The provisions have increased the control over the mandatory licensing of lawyers by the executive branch of government and cut the total number of lawyers licensed to practice advocating drastically. The right to assistance by a lawyer is essential in upholding the rights to liberty, freedom from torture, and the right to an effective remedy for human rights violations, including torture and other ill treatment. Amnesty International is concerned that the effect of the harassment and persecution of lawyers in Tajikistan, combined with the recent drastic reduction in the number of advocati, is undermining the respect for rights in the country and restricting further the already limited access to justice for all citizens, not only for those charged with national security-related offences. Thank you.
Thank you. So next we have Turkmadi Media, followed by the Institute for Reporters, Freedom and Safety. If I can invite Turkmadi Media to take the floor.
Good afternoon, Madam Moderator. I'm Dr. Urtok, and drawing your attention to judiciary breakdown in Turkey. No doubt, the coup attempt of 15 July last year was an attack on the democratic order of Turkey. The state of emergency declared by the Turkish government, however, led to incitement to hatred, atrocity, crimes, massive human rights violations, and the collective punishment and arbitrary persecutions of people on the basis of their ties to the Gülen-inspired Hizmet movement. Since then, Gülen movement was scapegoated and failed coup attempt pretext and turned to be a political coup to half-establish democracy in Turkey, resulting loss of separation of powers and all powers collected in one hand. As soon as the state of emergency declared, this gave government to fully control legislature, execution and judiciary, which are core foundations of functioning democracy. State of emergency extended for 3 times. In the meanwhile, President called for referendum for change of constitution, which enables his position from ceremonic to executive presidency. The new constitution will be used from 2019. However, with the state of emergency, there is already de facto autocratic presidency in the country. The state of emergency is also interpreted uphold of constitution and the country being governed with arbitrary governmental decrees. Literally, whatever policy government wants to implement passes as law, removing check and balance mechanism in the country. The censorship on the media is far-reaching, and thousands of civil society organizations have been shut down by 24 emergency decree laws. Particularly, the extreme demolition of the rule of law through the widespread persecution of lawyers, journalists, judges, and prosecutors is a clear evidence for Turkish government's abuse of state of emergency to establish an atmosphere of fear and silence each and every opponent. Currently, 4,500 dismissed judges and prosecutors, 513 lawyers, and 234 journalists and media workers are under arrest, with a further 867 lawyers being prosecuted. Most of them are detained without being taken to a court on the basis of poorly grounded accusations of supporting terrorist organizations. As finalizing, I want to underpin that an independent judiciary is an essential component in upholding the rule of law in a free society. It is unacceptable to go back in democracy, pretexting coup attempt by blaming Gülen movement to collect legislature, execution and judiciary in one hand in Turkey, an EU accession country. Thank you very much.
Thank you. So now we have the Institute for Reporters, Freedom and Safety, followed by the International Association for the Defense of Religious Liberties. Can I have the Institute for Reporters, Freedom and Safety, please? Thank you.
Thank you, Madam Moderator. I make my speech on Russian.
In my statement, I would like to cover all 3 of the main themes. First of all, the right to a fair trial. In Azerbaijan, we lost the right to a fair trial a long time ago. and a large number of decisions of the European Court of Human Rights in Strasbourg show that it is not possible for Azerbaijan citizens to obtain justice. Ilgar Mamedov, an opposition politician who's been languishing in jail for some 5 years, despite several appeals from the Committee of Ministers and a decision of the European Court of Human Rights which decided that he should be immediately released because the arrest was politically motivated, and yet he remains in jail. How can you pretend that the judiciary is independent when the Council of Judges is presided over by a cousin of the president who is also the Minister of Justice? The authorities have not been changed in Azerbaijan for a long time. All they do is change the constitution in the wrong direction every now and then. There is no real legislative action as such. Over the last few years, the liability of the powers and their accountability vis-à-vis the people has been weakened. In the last few years, starting from 2009 and through to 2016, all sorts of measures have been taken that have actually reduced the constitution to naught. There is no democracy. It's become a kleptocracy. When the Minister of Internal Affairs can appoint his young son, who's just my age, as his deputy minister, and when that is done by other civil servants and officials, when the president appoints his own wife as the first vice president, despite the fact that no one has voted for her, and when this is looked upon with irony by the entire world, and yet he doesn't care. It's very difficult to accept all of this. It's become a bit absurd and ridiculous. And as long as other OSCE participating states allow for leaders of a country like Azerbaijan to launder millions or even hundreds of millions, $3 billion, I think, in total, to launder them in Western banks, and then take advantage of that money to organize elections with so-called positive observers. As long as that is the case, then we won't be able to resolve the situation. So please close down those channels for laundering dirty money and put pressure on the authorities of Azerbaijan to get their act together. Otherwise, the principles of the OSCE will remain nothing but a dead letter. Thank you.
Liberties, followed by the Commission of the Protection of the Illegally Accused. So if I can invite the International Association to take the floor. And just a quick reminder to participants, if you can please give your name and the organization, institution, delegation you're affiliated with when taking the floor. Thank you.
Thank you, moderator. My name is Dr. Livio Olteanu. I'm representing International Association for the Defense of Religious Liberty from Switzerland. Excellencies, ladies and gentlemen, distinguished guests and colleagues, today more than ever, the people are challenged in their daily life with the issue of insecurity, persecution and torture, terrorism and international crisis. As I expressed at the first meeting which we had recently practically in New York and in Rome last days regarding the situation of security, in the context that we have today, we need to take in attention, to give us special attention to the religion regarding the analysis of contemporary issues. The people which don't give this attention assume great danger. Antonio Guterres, the Secretary of the United Nations, underlined recently, around the world we see the religion how it's being twisted, cynically, manipulated to justify incitement to violence and discrimination, and an alarming rise online and offline of hate speech messages that spread hostility and hatred. In the context of topic debated today, permit me to propose to OSCE to give a special attention to the following issues. First, tackling societal root causes, discrimination and equality, racism, negative stereotypes and prejudice, lack of prudence and populism, and utilization to religion for political gains. Second, member states to be encouraged regarding integration and respect for differences of every human being while respecting one's own cultural identity. In this way will be discouraged the hate speech, religious hatred, violence, discrimination of all people that specifically affect the religious minority. Third, to combat stereotypes, it should only be restricted to criminal offenses following the principle of legality, proportionality and necessity. Fourth, member states to have a clear separation between the political and spiritual aspects, condemning the repressive and arbitrary laws on discrimination based on religion and cultural identity. Also, the secular countries to be prudent on the religious expression and signs that may be restricted without a clear public interest justification and end up negatively affecting the enjoyment of other rights as well. And the last, member states to be monitored not to use extremism and national security as multi-purpose tool and pretext of political abuse against religious groups and minorities, dissident and political opponents. Concluding, the government do not journalists, social media and religious or belief minority, and not to manifest discrimination, intolerance and persecution against the freedom of conscience of the person. Nation and people need to develop a deeper understanding of religion and philosophical conception of other civilization, religions, culture, and teaching to live with differences, protecting for one side the civil security and for others side fundamental freedoms. Thank you so much.
Thank you. Now we have the Commission for the Protection of the Illegally Accused, followed by Justice International. If I can invite the Commission to take the floor.
My name is Oris Shevchuk. I'm from the Commission for the Protection of the Illegally Detained or Accused. The judicial control in Ukraine in principle exists at all times, at all stages of the procedure, but from the very time of detention, there are problems with procedure in guaranteeing rights. Let me give you an example. On 4 September 2017, in the center of Kiev, a journalist was detained by members of the security service. This was more of a kidnapping than a detention. She was kept all night by the Secret Service people. She was never charged, but it was she cooperated with a publication called Shari.net and a journalist who is now a political refugee in the EU. Another example, Oleg Kabrishin was detained on 20 March. This was illegal. A complaint was submitted, but no investigation was ever completed. And then there was another example of someone who was detained while at a doctor's office with his 3-month-old son. He wasn't given access to a lawyer for 12 hours after the detention. And any complaints submitted to the police were simply ignored. And then there is the guaranteeing rights during investigation. There is a constitutionally guaranteed right to privacy and secrecy of one's telephone conversations, in particular, in principle. Listening in to telephone conversations or keeping someone under observation is possible only on the basis of a judicial decision, and yet it is very frequently done without any decision from a judge. There have been some concrete cases. And I might draw your attention to the case of Ivan Kostienka in Kiev, where there was a record signed on minutes of an interrogation signed on one day. The next day, there was a different version signed by someone else. Then the case of Stanislav Serbaev. This individual was sentenced. At the present time, there are new circumstances, and so there is an appeal, but you can read more about that in the written version. Now, what about independence of the judiciary? Well, there is an organization called the ATO, which essentially is controlled by entrepreneurs, with Poroshenko's support, of course, and militants from the ATO go to courtrooms and they essentially demonstrate until they get the decision they want. And something to review that is almost impossible. Appeals courts essentially support whatever is decided in the court of first instance. And so I can't give you my recommendations, but they'll be submitted in writing.
Thank you. So now we have Justice International, followed by the human rights movement, Birdvino, Kyrgyzstan. Justice International, you have the floor.
Thank you, Madam Moderator. My name is Jasmine Cameron. I represent Justice International. Lawyers for Lawyers and Justice International organizations want to highlight the vital role lawyers play in upholding the rule of law by ensuring access to justice and protection of human rights, in particular due process rights and fair trial guarantees, while representing individuals and causes. Lawyers can only effectively fulfill their role as essential agents of the administration of justice if they can practice law freely and independently. We note with concern the increasing lack of respect for the independence of lawyers and legal profession. Member states must ensure that lawyers are able to advise and represent their clients without restrictions, influence, pressure, or undue interference from any quarter. There are countries, however, where the entry into or continuing practice within the legal profession is conditioned or controlled by the executive branch, and where the executive and judicial branches are using disciplinary, civil, and criminal procedures as means of pressure and intimidation of lawyers. Often, lawyers face new re-attestation or certification procedures or disbarment as means to control their abilities to represent clients in sensitive cases or as a tool of punishment for their activities. Lawyers are also identified with their clients or their clients' causes, and as a result, face attacks on their physical integrity, reputation, intimidation, arbitrary prosecution, and sanctions, including lengthy sentences. Frequent and systematic attacks of lawyers have a chilling effect on the whole category of legal practitioners. In some close authoritarian countries, lawyers are subject to undue interference with their freedom of movement restricted and certain travel bans applied, house arrests and other restrictions as well. In these countries, in particular, lawyers are facing many challenges, including the lack of access to their clients, lack of confidentiality communication with clients, lack of appropriate information, access to files and documents that enables lawyers to provide effective legal assistance. Because of the valuable role that lawyers play in ensuring the rule of law, lawyers should be respected and their work valued by the governments and members of OSCE. We call upon OSCE members states to continuously ensure that lawyers are able to perform all of their professional functions without any intimidation. Thank you.
Thank you. So now we have the human rights movement, Birdvino, Kyrgyzstan, followed by the public foundation Legal Clinic Adilet. So the human rights movement, the floor is yours.
Good afternoon, participants. My name is Aidia Bejmanova, and I'm a member of the human rights movement Birdvino, Kyrgyzstan. Our organization says on the 15th of October there are presidential elections, and in the pre- and post-election process, it's very important that laws be followed. At this moment, we can see, unfortunately, in Kyrgyzstan, the right to justice for each citizen is something that's important. Now, we've heard many colleagues talk about the many actions which have been brought to the courts against individual journalists and human rights activists. At the same time, when you're talking about human rights defenders, and particularly Adiba, and particularly certain individuals, we've seen that certain rights have not been respected. For many years, there have been defenders protecting the rights of the most vulnerable groups. We have recently focused very much on individuals subject to religious extremism. We've analyzed many cases in this regard of people who've been accused of extremism, and in all cases the accusations were made on the basis of Article 299, paragraph 2, which is the dissemination of extremist materials. Unfortunately, all of the accusations are made on the basis of expert reports coming from the State Office on Religion. According to the law, any material is extremist only following a decision of a judge. Many people are currently under detention, having been accused of extremism, and at the moment, each one of these people has been accused or brought to court without a court decision underpinning that. So if we're talking about specific cases, quite often our defenders cannot call witnesses to testify in the cases of these specific individuals. Quite often, at the time when searches are carried out, they're already in detention. So I think it's important in Kyrgyzstan to ensure this, and we need a full, thorough reform of the relevant authorities. Thank you.
Just take this opportunity to remind participants that it's a good idea to lead with your recommendations, just so that we get to hear them all. I appreciate that. So next we have the Public Foundation Legal Clinic Adilet, followed by the Almaty City Collegium of Advocates. If I can ask the Public Foundation to take the floor. Thank you.
Thank you, Madam Moderator. My name is Timur Sultanov, and I represent the Legal Clinic Adilet from Kyrgyzstan. In Kyrgyzstan, there is a violation of the right to a fair trial. There has been a limitation of the freedom of expression of lawyers and human rights defenders. The Prosecutor General, on the basis of a presidential decree, has opened investigations into the actions of journalists, and various fines were imposed in the value of several $1 million. This was never justified. This was essentially done because they made so bold as to interview certain individuals. Similarly, for lawyers, no reasonable time was offered for preparation of defense cases. There was a lot of pressure imposed. There was an unprecedented acceleration of the overall procedure. And this ended up in all of the requests of the prosecutor being accepted by the court. with decisions imposed on the lawyers and human rights activists who had to pay fines individually in the amounts of hundreds of thousands of dollars, which was simply impossible for them. There was also another sanction imposed, namely that of a prohibition to leave the territory of the country. Jean-Claude Foucault, for instance, has not been able to leave the country to this very day, and also the editor of an independent internet publication, Madame Maslova. And this despite the fact that the country has signed the International Covenant on Civil and Political Rights, where Article 12 says very clearly that every individual has the right to leave any country, and especially his own, and that measure to prohibit it can be imposed only on the grounds of national security. But here the Prosecutor General never indicated why there was a prohibition to leave the country. So these are flagrant violations by the executive of Kyrgyzstan, so we suggest that there be monitoring of court cases that are opened against representatives of the media or against lawyers or human rights activists, and that the government of Tajikistan receive appeals from the international community and pressure to bring legislation and practice in line with the standards of international law.
Public Bar Association, Kazakhstan. If I can invite the Collegium of Advocates to take the floor.
Yes. Здравствуйте,
Good afternoon, participants. My name is Daniel Arkanafin, and I'm a member of the Almaty City Collegiate of Advocates. We are a civil society organization protecting the interests of citizens involved in criminal proceedings. As a practical lawyer, I have to recognize that the procedures or proceedings in our country are excessively repressive. Only about 1% of verdicts handed down are not guilty, and often we see unjustifiable steps being taken. The rights are not duly considered. Lawyers protecting their clients are not able to provide the necessary guarantees. There are cases of lawyers whose own rights are not respected. They are harassed, and quite often their homes are investigated. In such situations, lawyers have difficulty raising their voice to protect human rights, but they do so in the hope that human rights of defendants can be respected. Recently, we've seen unprecedented pressures brought to bear on lawyers and advocates. We are greatly concerned by the Ministry of Justice's actions and the bill on lawyers' activities, which provides for a number of limitations on the independence of lawyers, the possible creation of a state advocacy. Now, this is pure legal nonsense. How can a lawyer working for the state protect a citizen from the law enforcement of that same state? This is clearly a major contradiction and not acceptable in a democratic state. There's also a disciplinary commission under the Ministry of Justice, and that is clearly against paragraph 28 relating to the role of legal experts, which says that there needs to be an independent disciplinary committee that applies to lawyers. The interference of the state in this process is an attempt to undermine the independence of lawyers. On the 14th of October in Astana, there will be a general meeting of lawyers taking a decision on how to respond, and we would ask all participants and people who are interested in this to participate. We hope very much that the authorities will not implement these changes which undermine the independence of lawyers. And we hope that through dialogue this problem can be solved. We believe that will help all parties. Thank you.
So now we have the Republic Bar Association from Kazakhstan, followed by the Astana City Collegium of Advocates. If I can invite the Republic Bar Association to take the floor.
Thank you. Уважаемые участники.
Distinguished participants, my name is Sergei Sizintsev, and I'm the Executive Director of the Republic Bar Association in Kazakhstan. I represent the Society of Lawyers of Kazakhstan, and like my colleague, I am duty-bound to express some very serious concerns about the draft law that is being worked on the work of lawyers. The standards of the draft really seem to aim at undermining the independence of lawyers, making it possible for the state to interfere in the work of lawyers. All of this is being drafted and pushed through Parliament extremely quickly without a proper legal analysis, without consultation, without open public commentary. The draft law removes a number of guarantees previously available to lawyers. It is possible for the finances of lawyers to be interfered in by the state. They can decide what the level of fees to be charged by lawyers should be. There is a need to have all of this reviewed. Some of the internal documentation of the Bar Association will be subject to review by the prosecution, which is entirely unacceptable. And there are certain functions of the bar that will be handed over to other professional groups. We believe that this is not in line with the Constitution or the international standards. And Kazakhstan has signed an agreement for closer partnership with the European Union. It promised therein to respect the principles of the rule of law, and yet what is currently being done in this draft is not in line with the rule of law. So we believe that in accordance with its international commitments, Kazakhstan should ensure full equality of parties in any judicial proceedings on the basis of the adversarial principle, and give the lawyers the possibility to regulate themselves, to punish themselves when that turns out to be necessary, and not to put these powers in the hands of other individuals who are in fact civil servants. These issues are very general in nature, and they really need to be taken into consideration, not on the basis of specific cases, but as general principles. Thank you.
City Collegium of Advocates, followed by the International Legal Initiative Public Foundation from Kazakhstan. If I could invite the Collegium to take the floor. The Astana City Collegium of Advocates.
Yes, hello to all participants. I come from Astana in the Republic of Kazakhstan. My name is Asil Tokayev. I'd just like to add to what's been said by my colleagues. The independence and guarantees provided by lawyers are under difficult circumstances as things stand at the moment. So the actions of the bodies trying to exert further controls on lawyers is something that has prompted us to raise concerns with the authorities. The access to justice needs to be a process where all involved have their own rights, but we're seeing cases where judges are trying to bring excessive influence to bear on lawyers. They cannot, at the moment, effectively protect their clients or protect the interests of their clients. They face the possibility of their license being rescinded or proceedings indeed brought against them. So the authorities are trying to influence and control lawyers. There are cases where when lawyers refuse this, they are stripped of their license. I myself have been a victim of this, where I had a complaint raised against me, and it's worth noting that the complaint was not rescinded by the court. It was taken to appeal. It was a clear attempt to impede an independent trial. This is still ongoing, and this is something that all lawyers in Kazakhstan are concerned about, as well as the international bodies ICG and IBA, who says that it constitutes persecution of lawyers for carrying out their professional duties. We see lawyers who are doing their professional duty, protecting their clients, being subject to such pressure. It is becoming almost impossible to work properly as a lawyer. Thank you very much for your attention.
Thank you. So now we have the International Legal Initiative Public Foundation Kazakhstan, followed by Azerbaijan. If I can invite the Public Foundation to take the floor.
Yes, thank you. Меня зовут Айна.
My name is Ashambaeva, and I'm a representative of the International Legal Initiative Public Foundation in Kazakhstan. I'd like to draw the attention of participants to the fact that the independent civil society in Kazakhstan is not able to exercise any kind of influence over the process of creation of legislation. The civil society is officially called upon to make comments, to consult about draft laws, and yet all comments and recommendations of civil society are not taken into consideration. They're not looked at seriously by the ministry that submits the draft law or by the parliament. And this means that year by year, the space for civil society to act is being reduced more and more. Especially when civil society is interested in protecting human rights. Well, that can easily end up in persecution. My organization, is being persecuted by the authorities of Kazakhstan for our human rights defense activity and also for our position of principle concerning protection of human rights. We had a broad-ranging campaign against the adoption of the law on the funding of NGOs. This is an analog of the notorious foreign agents law of the Russian Federation, which substantially reduced the space and the margin of maneuver for NGOs to function. It really limits the way in which NGOs can be funded. So we organized this social campaign that was supported by more than 160 organizations. And after this, we started to be persecuted by the judicial bodies of Kazakhstan. We have been stripped of our status of NGO, and we have to pay taxes as if we were a corporation. So we would appeal to the authorities of Kazakhstan to cease to persecute us for our legal civil society activity, and also to take the views of civil society more into consideration when legislation is being drafted, especially when it concerns human rights. Thank you.
So now we have Azerbaijan, followed by the Human Rights Educational Center. If I can invite Azerbaijan to take the floor.
Thank you very much. Dear Madam Moderator, ladies and gentlemen, Efficient, impartial, and independent judiciaries are the cornerstone of any functioning system of democratic checks and balances. They are the means by which powerful interests are restrained according to the laws of the land. They guarantee that all individuals, irrespective of their backgrounds, are treated equally before those laws. The judicial systems that are best able to perform are those which exhibit high levels of independence and impartiality, and which command solid public trust. The experience shows that the right laws and structures are the key to judicial independence, but alone they are not sufficient. Proper checks and balances are needed to ensure a separation of powers between the judiciary and other branches of power, and just as crucial is a culture of independence and impartiality. With this particular purpose in mind, the Judicial Legal Council has been established in Azerbaijan. Today, the Council deals with all issues with regard to the judiciary. Among them, selection of judges, evaluations of their performance, career advancement, questions related to liability and reward, just to name a few. At the same time, Council's powers are constantly expanding in terms of its independence. So far, 11 amendments have been made to the law on its status. Having attached special importance to the issue of transparency, Azerbaijan developed the system of election of judges, which had been acknowledged by the Council of Europe and the European Union as an interesting model of best practice by emphasizing it in the separate study number 22 on high-quality justice addressed to all member states. Thanks to the above-mentioned system, we brought up a new generation of judges who already make up 60% of judge corps. Another equally important issue is the need for financial independence of the judiciary. In this regard, it is worth mentioning that judges' salaries in Azerbaijan are fixed by the law and, despite economic difficulties, constantly increasing. In addition, reduction in judges' salaries was banned by corresponding legislative acts. Judges' working conditions, equipping courts with modern information and communication technologies also play an important role. So far, conceptual new courthouses had been built for 11 courts in Azerbaijan, and new ones are under the construction. Old courthouses are equipped with the latest ICT, transforming them into the high-tech courts. Number of judges and court clerks is another important factor in terms of ensuring the independence of the judiciary. Bearing in mind that in accordance with the CEPESH statistics, Azerbaijan had a very low number of judges. The Judicial Legal Council initiated a twofold increase in the number of judges. In addition, the number of court clerks was increased by 25%. We attach great importance to international cooperation and exchange of experience in this field. Therefore, Azerbaijan acted as one of the co-initiators of the International Association of Anti-Corruption Authorities. Just to say in conclusion that I would like to conclude by well-known wisdom. All the rights secured to the citizens under the Constitution are worth nothing and is a mere bubble except guaranteed by an independent and virtuous judiciary. I thank you for your attention.
Thank you. So now we have the Human Rights Educational Center, followed by the Human Rights Embassy. If I can invite the Educational Center to take the floor.
Thank you very much. Уважаемые участники.
Participants, moderator, Belarus for almost 23 years has seen Lukashenko define the law arbitrarily. Judges don't really follow any independent law. Defendants' rights are really not observed, and there are military and law enforcement agencies that simply act independently. Apparently terrorists don't exist in Belarus. Europe is worried by terrorism, and Lukashenko wants to show that we are fighting it as well, making demonstrations of acting effectively, but in fact, there are ridiculous charges being brought, such as gesturing with one's hands. What country seriously has a law against gesturing with one's hands? We see many such trivial charges brought. Recently, Lukashenko said that for higher education, 3 years was enough. And that it was necessary to simplify the textbooks. Today, we have the situation of the national flag. There was a decree brought by the president relating to the flag, but the white and red flag today is a course of, seen as a source of dissent. After the celebration of the Independence Day on the 25th of March, Independence Day, many people were brought before the courts. There were demonstrations against this. There are no independent states. There is no independent courts, no independent judiciary. There is no effective law. The law is effectively what Lukashenko decides. EU and Germany especially need to understand that there is no democratization of Belarus, no liberalization. It is, as always was, a dictatorship.
Thank you. So now we have Human Rights Embassy, followed by the International Federation of Human Rights. If I can invite Human Rights Embassy to take the floor.
Thank you. Leila Mitreveli, Human Rights Embassy, Moldova. Dear colleagues, on behalf of Human Rights Embassy and our partners, I would like to draw your attention to the deterioration of the state of justice in the Republic of Moldova. During HDIM 2016, we reported on the inadmissible interference in the legal profession through the cases of human rights lawyers, defense attorneys, Vyacheslav Tsurkan and Maxim Bilinsky, that have faced criminal charges related to their work. These cases are only two amongst others. Anna Ursaki, present here, and others, in which lawyers' rights are infringed, namely their right to independence and freedom of exercise. Their criminal cases are accompanied by procedural violations and bear signs of political motivation. These cases illustrate well-founded concerns around illegal and selective forms of justice, including concerns that the justice system is being used as an instrument to combat perceived political opponent. Another case, the case of dismissed Judge Dominika Manole, shows serious signal of attack on the independence of judiciary. Just recently, the Superior Council of Magistracy declared Judge Manole incompatible with Judge's office and proposed to the President of the Republic of Moldova her dismissal. The decision on dismissal was contested at the Supreme Court of Justice, as this is the only judicial remedy to verify the legality of the Superior Council of Magistracy decision. The first hearing to examine the appeal was set for 4 August 2017, and it was very logical to wait to decide on the proposal on dismissal only after the case has been finalized by the Supreme Court of Justice. However, on 21st July 2017, the President issued the decree to dismiss Mrs. Manole from the post of judge, the fact that strengthens our concerns regarding pressure on the judiciary in Moldova. Information on the case of Judge Dorin Munteanu will be provided by my Moldovan colleagues later on. Our recommendations. We call upon all national authorities, first, to uphold its international obligations, to take all necessary measures to respect, protect, and promote the freedom of exercise of the legal profession without improper interference, as it affects fair legal representation and damages the rule of law in general. Second, to respect the independence of judiciary, which is a pillar of rule of law and democracy. We call on international organizations, in particular the OSCE, Council of Europe, European Union, and United Nations, to monitor the state of justice and to intervene by means appropriate to each organization to stop the deterioration of the state of justice in the Republic of Moldova. Thank you.
Thank you. So now we have the International Federation of Human Rights, followed by the Kazakh Community Association. Can I invite the International Federation to take the floor?
Thank you, Madam Moderator. My name is Julia Wano, and I represent the International Federation for Human Rights. We wish to raise the topic of the right to a fair trial and the independence of the judiciary in the context of death penalty application in Belarus. Human rights defenders estimate that since Belarus gained independence, about 400 people have been executed. The exact number of persons convicted to death and executed in Belarus is unknown, since information concerning the death penalty is withheld from the general public in violation of Belarus international obligations, including those to the OSCE. In Belarus, during pre-trial, torture and ill treatment are widely used to force suspects to incriminate in the absence of a lawyer, including those charged with death-eligible crimes. Legal counsel is not providing following the arrest, as required by national legislation. Self-incrimination is often used by the prosecution as the main evidence of guilt, while the right to an effective legal defense is systematically violated. Lawyers and judges generally lack independence, as does the judicial system as a whole. Lawyers in Belarus are under the tight control of the Ministry of Justice, which is in charge of organizing qualification exams, initiating disciplinary proceedings against lawyers, and suspending the activities in cases of misconduct. It carries out state registration of bar associations and law firms and is empowered to control the management of bar associations. Requirements to pass additional qualification exams are used as a tool to pressure lawyers, and several independent lawyers today risk losing their license. Belarusian legislation violates the principle of judicial independence and the non-removability of judges. Indeed, the executive plays a key role in the appointment of judges and has the authority to initiate disciplinary proceedings against them, including their removal from office. Talking about death penalty, an example of the lack of the independence of judges would be a case when the president intervened directly in judicial proceedings after the Supreme Court softened a death penalty to life imprisonment. Death sentences issued by Supreme Court as a first instance court are not at all subject to appeal in violation to international norms. The UN Human Rights Committee has requested in 10 different cases that the Belarusian authorities not carry out sentences pending their examination by the UN. In all cases, Belarus has disregarded this request, and in 6 of the cases, the Human Rights Committee has subsequently found numerous basic rights violations, including the right to a fair trial and, as a consequence, the right to life. In this context, FIDH urges the OSCE to closely monitor death penalty application in Belarus and, awaiting the moratorium or direct abolition of death penalty, to urge for full transparency of data and to call on the Belarusian government to bring its legislation and practice in compliance with international standards of fair trial. Thank you.
Thank you. So next I have the Kazakh Community Association, followed by Political Movement Group 24. If I could invite the Community Association to take the floor.
Thank you, Madam Moderator. My name is Mali Majets, and I'm from the Kazakh Community Association and a president of the Kazakh opposition abroad. In Kazakhstan, Aron Adegiev has been, he's a citizen, he's a political prisoner, a dissident, and was a dissident back in the Soviet Union. I have been pleading the case of this individual before the OSCE for 10 years, and he's still in jail. In 2007, he was sentenced to 18 years in high-security prison for a supposed illegal activity in the city of Almaty. There was a protest there, and in the following the protest, one of the police officers died, and Aron Atabieg was charged with that. He was sentenced to years, and his three colleagues were sentenced to 14, 15, and 16 years. They've all been in prison for 8 years already. His daughter has not seen her father for 10 years. We don't know the state of his health. Perhaps he is subject to physical and psychological pressure or even torture. We believe that this is a policy not just of the penitentiary, but also of the local officials and of the president, because he criticized the president and not just the government. Since 2016, Maksabayev and his other colleagues have been in prison because they have tried to protect property owners from having their real estate forcibly sold off. There has been an assessment by international organizations to the effect that the trials against these individuals were unjustified, but there has been no reaction by the Kazakh authorities. Similarly, another individual sentenced to 12 years and in prison with no health care. Lusivnov, Tosambayev, and several others are in prison, and this they were trade union leaders. This has essentially resulted in the disappearance of independent trade unions. So we want recommendations to be made to the authorities of Kazakhstan that they not prevent international groups from getting in touch with these political prisoners, that all political prisoners in Kazakhstan be released would be another recommendation. Thank you.
So now we have Political Movement Group 24, followed by the Center for Democracy and Rule of Law. So if I could invite Group 24 to take the floor.
Thank you, Moderator. I'm Said Ali Ashurov, activist Political Movement Group 24. Rule of law. Laws and procedures should be applied fairly and equally to all citizens. All citizens are equal under the law. No one is above the law, not even a king or an elected president. Tajikistan by constitution is a democratic, secular state and based on the rights, but unfortunately the above arguments are limited by the regime. Because of dictatorship, since 1992, the constitution of Tajikistan was changed 3 times by Rachmanov's will. After the last amendment to the constitution of Tajikistan on 22 of May 2016 and accepting the rule of leader of the nation, the remain laws and judiciary system cracked down. The rule gives Imam Ali Rachmanov unlimited presidential power and inviolable to talk about his governor and his family. Behind this rule, his decision became over the constitution and nobody will be able to against him. Judiciary system in the country is under the Rachmanov's control, and without his assessment there will be no implement any constitutional law. As a result, many innocent citizens condemned without any reason, especially members and followers of the political parties. So judiciary system is not independent at all, as Rachmanov's choice is about everything. Whenever Imam Ali Rachmanov's regime is on the power, there will be no any democratic law and will of citizens. Since his repression, many democratic parties, institutions and associations were bonded and their founder members were detained and arbitrarily exiled. For example, Mohammad Ruzi Iskandar, founder of the Democratic Party, sentenced for 23 years. In my conclusion, I invite whole democratic institution and concerned authority of OSCE and other organizations to focus on the issue and give alternative way of solution for the issue. Thank you for attention.
Thank you. So now we have the Center for Democracy and Rule of Law, followed by Georgia. If I could invite the Center for Democracy to take the floor.
Thank you, Madam Chairman. Good afternoon, dear participants. My name is Helena Chizhik. I'm a Public Integrity Council Coordinator, Ukraine. And I will speak on behalf of civil society observing the Supreme Court competition in Ukraine. First of all, I agree with Mr. Sergei Kozyakov the head of High Qualification Commission of Judges of Ukraine, that the Supreme Court competition is a model process. The procedures were very progressive and unprecedentedly open. I would like to personally thank Mr. Korzykov for taking leadership in organizing that process. At the same time, the results of the competition are not so optimistic. 30 finalists out of 120 do not meet the integrity criteria upon Public Integrity Council opinion. We have facts in open access that proves that these candidates are dishonorable. As a result, a number of notorious judges who are the very symbols of corruption are likely to become the Supreme Court judges. Among them, there are judges who grossly violated human rights, as the European Court of Human Rights has recognized. Candidates with a mismatch between their declared income and their assets. Judges who prohibited peaceful protests during the Euromaidan, and 2 judges who made a politically motivated decision against Yuri Lutsenko, who is former Minister of Interior Affairs and now he is General Prosecutor of Ukraine. While the Council of Europe clearly stated that the case of Lutsenko was politically motivated prosecution, these 2 judges who convicted Mr. Lutsenko also made the final round within the Supreme Court competition in Ukraine. That shows that even the most transparent procedures are worthless if the result is unsatisfactory. Therefore, recognizing all the progress, I must admit that we still need to work on two things. First of all, not letting the notorious candidates be admitted, but that is in the hands of the High Council of Justice. And second of all, improving procedures, criteria of evaluation, and the most important one, the transparency of decision-making within the Commission, so we do not have such cases in the future. And last but not least, on Friday's morning, the Public Integrity Council holds a side event where we will present the Ukrainian experience of public participation in the selection and evaluation of judges. I kindly ask you to join the event. Thank you.
Thank you. Now we have Georgia, followed by the Crimean Human Rights Group. If I can invite Georgia to take the floor.
Thank you, Madam Chair. My name is Ketevan Saratishvili, and I represent the Ministry of Justice of Georgia. Reinforcing rule of law, protection of human rights, and consolidating of institutional democracy has always been the mainspring for the government of Georgia. For that reason, we are committed to develop a strategic approach to ensure the implementation of obligations stemming from the human rights in everyday life, with the view to build interagency, multi-sectoral, unified and consistent policy. In the light of rule of law, judiciary is the first and the most important item in the sequence of reforms in Georgia. Here, our efforts focus on institutional safeguards to ensure independence of judges. Its essence is to empower ordinary judges to exercise self-rule, to run the High Council of Justice, as well as provide an avenue for participation of the civil society. As a result of comprehensive judicial reforms, we have introduced clear and objective criteria for the pre-life appointment of judges, a principle of automatic and electronic distribution of cases, etc. Obviously, we acknowledge that there is always room for improvement, and we highly appreciate the support and encouragement of the partner states. Therefore, we firmly continue our ambitious plans and considering to introduce specialized commercial chambers within the judicial systems in Georgia, which will have jurisdiction over high-level commercial cases. Beyond the reform of the judiciary, intensive efforts of the government of Georgia should be outlined, aiming at reinforcing the anti-corruption measures, establishment of accountable and transparent governance system. Notably, Georgia was one of the first countries to join the Open Government Partnership in 2011. Throughout our OGP journey, Georgia was elected as a steering committee member in 2014, co-chair of the partnership in 2016, and today the government of France, the current chair of OGP, will hand over the chair position to us. As the chair of OGP, we have identified 3 strategic goals aiming at enhancing citizen engagement and citizen-centered governance, advancing transparency and fight against corruption, and third, generating innovation in public service delivery. The government of Georgia is committed to continue reforms in the field of rule of law, judiciary, and human rights. Thank you.
Thank you very much. So now we have the Crimean Human Rights Group, followed by the Open Dialogue Foundation. If I could invite the Crimean Rights
Thank you.
Group to take the floor.
My name is Alexander Sedov. I am representative of Crimea Human Rights Group. I would like to inform you regarding the use of judicial system of the Russia to the violation of fundamental human rights in the occupied territory of Ukraine. From the very first day of occupation, the Jews in Crimea were selected on the principle of loyalty to Russian Federation. This led to the fact that the judicial system in Crimea turned from an organ justice into the mechanism of punishment. Crimea Human Rights Group conducted an analysis of judicial decisions that were made in Crimea since the beginning of the occupation. As a result, there were recorded lots of decisions on the punishment for the freedom of peaceful assembly, freedom of speech, freedom of religion. There are several decisions made for the action committed before the occupation of Crimea. Such this prosecution violated the principle non-punishment without the law. We found 256 judgments on the punishment applied to participants of the peaceful assemblies. The total amount of fines on the orders is more than 2,700,000 rubles. The amount of some fines reached 150,000 rubles. It should be noted that the average pension in Crimea is less than 9,000 rubles. In addition to the penalties, participants of peaceful assembly were sentenced to the compulsory public work and administrative arrest. Part of the fines for participants in unsanctioned rally was applied to participants in religious events. For example, in 2016, a court in Yalta fined the Krishnaid because he walked along the Yalta embankment. Also, 6 fines employees were recorded for the missionary activities. For example, in June 2016 in Yalta, a member of Jehovah's Witnesses organization was fined for worshipping, reading the Bible, singing songs, and praying. We regularly recorded cases connected with penalties in the form of administrative arrest and fines for pro-Ukrainian and religious posts on the internet. In July of this year, in Crimea, the fact of imprisonment for 1 year and 3 months for a post on social network is recorded the first time. The analysis of judicial decisions speaks about strengthening of punishment in Crimea for the expression of the right and the freedom. The side of fines is growing. In addition to the administrative persecution, 40 people are currently deprived of their liberty. For example, of such persecution in the case of Akhtem Chigos, who was sentenced to 8 years in the prison a week ago for organizing a peaceful rally before occupation, at the time when even the Russian Federation considered Crimea as a part of Ukraine. Or the case of Vladimir Bargul, who was sentenced in August for 3 years and 7 months of imprisonment for not being afraid to post a Ukrainian flag on his house. The above fact indicates that now the Jews in Crimea are just being screened for legitimizing political persecution directed by the Russian authorities. Thank you.
Thank you very much. So next we have the Open Dialogue Foundation, followed by the National Bar Association of the Republic of Moldova. If I can invite the Open Dialogue Foundation to take the floor.
Thank you very much. My name is Ludmila Kozlovska. I represent Open Dialogue Foundation, which is dedicated to protect human rights and rule of law. It's first time when I speak about situation in Poland, and usually we present Poland as a successful example of reforms, of transition for post-Soviet countries. But this time I have to speak about unprecedented attack for NGOs and opposition because of their peaceful protest and basically about their position against judicial reform in Poland. Non-governmental organization critical to the state authorities, including Citizens of Poland, Open Dialogue Foundation, ourselves, Committee for Protection of Democracy and Action Democracy have been been subjected of unprecedented pressure due to their objections to the government plans of the judicial reform and involvement in peaceful society protest in the second half of July 2017. Controlled by ruling party, Polish public television TVP has launched a massive defamation and slander campaign against the aforementioned organization, and more broadly, all citizen-led independent initiatives. Media attacks are prelude to harassment by government administration, which brings to mind the methods used in Poland during the communist era and now in numerous non-democratic post-Soviet countries. Members of the Polish government, such as Ministry of Interior, his deputy, Minister of Coordinator of Poland Special Services, Minister of Foreign Affairs, Minister of National Defense, publicly discuss action which should be taken against particular NGOs. In case of Open Dialogue Foundation and Citizens of Poland, the Polish government is about to demand the suspension of the foundation management board. In case of Open Dialogue Foundation, Minister of Foreign Affairs, in cooperation with Minister of Special Services, have launched a special fiscal and custom inspection in our organization, despite the fact that different inspections have been already carried out in previous years. On July 27, police recording of surveillance activities against activists of Citizens of Poland and one of the leaders of opposition party Nowoczesna, which means modern, Ryszard Petru, saw daylight. It became apparent that the largest civil opposition movement, Committee for the Defense of Democracy, faced similar problems. Hostile actions against particular NGOs and critical civil society as a whole are being carried out by right-wing members of the parliament and members of European Parliament from Poland. We hereby invite members of the OC to call upon the Polish government to restore a normal course of democratic European standards and guarantee the independence of civil society initiatives in Poland. Thank you.
Thank you. So next we have the National Bar Association of the Republic of Moldova, followed by the OJF Armenia Justice Group. If I can invite the National Bar Association.
Thank you, moderator. I'm Anna Ursaki, member of the Bar Association of Moldova and human rights defender, and I will ask you permission to switch to Russian because suddenly I decided to change the topic, the subject of my presentation, and then in the end of the presentation I will explain why. Дорогие друзья,
So, friends, during my career in the Republic of Moldova, I've had to protect a lot of dissidents and dissenters. I've seen them become victims of oligarchs. The oligarchs came to power. I was one of the lawyers who participated in some of the best-known trials where there was an illegal arrest of people participating in peaceful protests against the powers, people representing major opposition parties and key witnesses who wanted to testify against the worst oligarchs who sit behind the wheel of the Republic of Moldova. I was in Berlin at the OSCE having enough evidence about the crimes of the Moldovan regime. I brought this evidence, requested sanctions and bringing to justice of those who had embezzled millions in Moldova, embezzled millions in just one day at the end of 2014. I wasn't able to go home because there was a campaign against me and criminal proceedings. But it's not this example which is so bad, but the fact that all lawyers who came to visit me were also subject to criminal proceedings. There was a particular judge who put out an arrest warrant, and my lawyer defending me was also subject to criminal proceedings. All of those people who are trying to do this work are very afraid that similar things will happen to them. At the outset, I said that I wanted to talk about anti-democratic laws that have been adopted in Moldova. However, I understand that behind this there is the law of electoral reform. We fully understand the issues behind this, that there are macro-financial issues. We would ask the OSCE, the European Parliament, the Council of Europe to apply sanctions immediately against all of those who today are working against the rule of law in Moldova and ensure that Moldova complies with all of its commitments taken up when it signed the agreement on association.
So now we have OJF, Armenia Justice Group, followed by the Helsinki Citizens Assembly, Vanadzor. If I can invite the Armenia Justice Group to take the floor.
Здравствуйте, уважаемые дамы и господа.
Good afternoon, ladies and gentlemen. I'm a lawyer from Armenia. I represent the Justice Group. Our recommendations amount to calling on the authorities of the Republic of Armenia to cease to deal in an arbitrary manner with lawyers, and to call on the authorities of Armenia to ensure fair trials and access to justice, especially in cases that have a political undertone to them. In April of last year, there was an action in Armenia when armed people took control of a police station, and then they handed over the arms. But now there are trials brought against these people that show how easy it is to ignore people's procedural rights. There is an unprecedented case in a court where a correspondence between a lawyer and the person he was defending was taken by the police, submitted to the court, and it was recommended that the lawyer in question be barred from participation in the trial. And then the defendants were forcibly removed from the courtroom. They were beaten. They were taken to the basement of the court building, and the judge continued the trial and said not a word about the fact that the defendants in question were no longer present. As for lawyers, under various falsified pretexts, they were not admitted to the courtroom. The defendants were defended instead by lawyers appointed by the authorities, and all of this is happening right now in the 21st century. I mean, it's absolute regression, hence our recommendations.
Thank you. So next we have the Helsinki Citizens Assembly, Vanadzor, followed by the Protection of Rights Without Borders from Armenia. If I can invite the Citizens Assembly to take the floor.
Спасибо.
Thank you very much, Artur Zakun. I'm representing the Helsinki Citizens Assembly, Vanadzor. Ladies and gentlemen, Armenia is not observing the principle of independent trials, particularly with regard to issues which are clearly of a political nature. In a country where the rule of law and democracy applies, you can't really talk about political trials, but that is what we are dealing with. The Armenian authorities are using all means available to bring fabricated accusations against their political opponents. they have to stop this criminal prosecution against Andreas Yukovsiana, Zilaria Tsefifiana, and Karogek Mukana. And at the same time, when we are witnessing a conference of Armenian diaspora, the police are using dubious reasons to imprison other individuals. For example, the supposed planting of a bomb. There are also minors who have been subject to similar behavior. With further police prosecution of an individual called Aksona, who has been arrested 31st of July 2016, was in custody till December, was then released because of his health condition. In February 2017, the court decided to change its decision, extending imprisonment for 2 months. The court decisions led to further detention, a worsening of health, and ultimately death. Saksyanov's second arrest was illegal, and to date there has been no objective investigation into the causes of the arrest, imprisonment, and death. Thank you very much indeed.
Thank you. So now we have the Protection of Rights Without Borders, Armenia, followed by the Humanitarian Legal Center. So if I can pass the floor to Protection of Rights Without Borders.
Madam Moderator, I'm Rax Melkonian from Protection of Rights Without Borders, NGO Armenia, and I would like to address the independence of judiciary with respect to the cases of application of detention as preventive measure in the criminal investigation. According to the state-provided statistics, more than 95% of motions by the investigation and prosecution are being satisfied by Armenian courts, particularly this year, 2017. During 6 months, 155 motions out of 1,155 motions out of 1,215 on application of detention was satisfied by Armenian courts. Moreover, the motions of extension of detention period was also had much more satisfaction percentage. Out of 1,733 motions, 15 only have been rejected. These numbers speak about themselves. Moreover, the percentage and the cases of the European Court of Human Rights proves that Armenian authorities, courts mainly fail to properly examine the notions and motions and the evidence provided by the investigation, and European Court of Human Rights stated that usage of stereotyped formula and standardized language in the decisions is a recurring problem in Armenia. Moreover, detention in Armenia is applied to the opposition leaders and political opposition members to silence and isolate them, and as a punishment for them to make pleading guilty. One of those prominent cases which I want to refer to is the case of Andreas Vukasyan, as my colleague stated already. He, together with other 8 people, was accused of organizing and participating in mass disorder on July 29, 2016 in Yerevan, and detention as preventive measure was applied to him. Currently, Andreas Vukasyan is the only person out of those 8 who is under detention. The motion to prolong the term of the application of detention as preventive measure towards him has been discussed in more than 16 closed sessions, and as stated by his lawyer, they have not have any possibility or proper possibility to examine all the evidence provided by the investigation. At the same time, other political leaders like members of opposition, David Sanasaryan, Armen Martirosyan, Hovsep Khurshudyan, who like Andreas Vukasyan were detained in the same ground of organizing and participating in mass disorders, are free now due to the pressure of international organizations, and they are now free under bail. In this respect, I would like to also state that the Vukasyan case is prominent because appeals at the appeal court, the judge himself asks whether he is going to continue his political opposition activities, and when he promptly answered in positive, the court decided to continue his case, his detention. Thank you for your attention.
Thank you. So now we have the Humanitarian Legal Center, and then the last speaker on the list, which is the Europe in Law Association. And after those two speakers, we will move to rights to reply. So if I could have the Humanitarian Legal Center.
Thank you, Madam Moderator. My name is Shukrat Ganyes. I'm from Uzbekistan with the Humanitarian Legal Center. The legislative reform underway in Uzbekistan at the present time on the initiative of the President were very strongly supported by the society. The society has seen this as a way of finally having an independent and dispassionate judiciary. Now, obviously, this is a very important reform. Over many years, the judiciary and judicial proceedings were organized in such a way that they always supported the powers that be. And now a law is being worked on the administrative legal proceedings, which is something that will reduce the burden of work of the civil and criminal or penal judiciary, because a lot of administrative violations can be dealt with by that separate system, and where the fates of individuals are not in question. Now, our study of this indicates that yes, reforms can be enacted, adopted, handed down from on high, but you can't change individuals so easily. Mentalities that don't change overnight. And judges still tend to hand down guilty verdicts and do not take into consideration the situations of individuals. But in the case of the administrative judiciary, because the violations in question and the fines in question are not very significant, they are just sort of easily handing down the guilty verdicts. This is resulting in a lot of complaints being submitted to human rights defense organizations. This is essentially because these administrative judges approach things in a kind of a standard way without taking into consideration the actual facts. So by way of recommendations, I would suggest that in Uzbekistan, this circumstance be taken into consideration. Maybe there needs to be more training, raising the qualifications of these judges. Maybe they need to be rotated. Maybe more attention should be paid to the fact that any individual who is a defendant is also a citizen, that there shouldn't be automaticity of guilty verdicts. Thank you for your attention.
Thank you very much. So the last speaker on the list, the Europe in Law Association. You have the floor.
Thank you. I'm representing Armenia European Law Association. My name is Tigran Yegorian. I'm going to talk about the fair trial and the independence of judiciary. There are systemic problems in this area of the existence of the right to fair trial in Armenia, in view of the fact that Armenian courts don't act as an independent and impartial tribunals. This problem is based on the issue of the formation of judicial power, as well as the overwhelming the punitive influence of the Court of Cassation by disciplinaries against judges. The impartiality of the courts and the corruption in this system was also recorded by the human rights defender in 2013 by a report. The impartiality of the president of Cassation Court was questioned by the European Court as well by one of its judgments. The recent trials of Sasnat's group and Sefilian's case are the best manifestation of the above mentioned facts. The first case is split into two different cases, but with one and the same judge will be sitting in two cases dealing with the same factual circumstances and taking judgments in both cases, which is impossible for the same person to act as an impartial tribunal. Second, the two judges are regularly removing the defendants from the courtroom and reasoning it by the contempt to court and determined to continue the trial in their absence. The protesting defense lawyers are being punished by sanctions and are being substituted by public defense despite objections of defendants. In addition to this, the authorities have introduced new search and seizure procedures against the lawyers to entry to the courtroom, and the lawyers who refuse to abide by the new procedures deprived of the right to be present, are deprived of the right to be present at the trial and represent their clients, and are being punished by the court sanctions. Finally, authorities are using the Armenian bar chamber as a tool to exert pressure on the protesting lawyers and instituting by disciplinary proceedings. Our recommendation is to observe these problems by and cover it by a report with current recommendations to the Armenian officials. Thank you.
Thank you very much. So now we will move to the rights to reply. We have 2 minutes for each, and I have 8 registered rights to reply. So the first is Kazakhstan, followed by the United States of America. If I can invite Kazakhstan to take the floor with 2 minutes.
Kyrgyzstan.
Kazakhstan.
No, Kazakhstan, Kyrgyzstan.
Our apologies, Kyrgyzstan.
Уважаемый модератор.
Moderator, ladies and gentlemen, thank you very much for giving us the opportunity to reply to a number of comments that were made with regard to our country. Kyrgyzstan recognizes the freedom of speech as one of the fundamental human rights. And therefore, we decriminalized certain articles, such as those relating to slander and defamation, which are now purely part of civil proceedings. There are no longer criminal liability for such acts. In accordance with the law and under international law, any citizen has the right to go to court to protect their reputation. In a number of democratic countries in the world, this is a widespread common practice and not considered to be a limitation on freedom of speech. So we believe that they apply the same principle to journalism as well, and the need to apply balanced information. Unfortunately, in our country, in regulating the same issues by bringing actions to court in a civilized way, this is interpreted as a threat to freedom of speech. I would like to note that the comments made by certain NGOs in regard to the decisions of the courts are not acceptable, because all are equal before the law, and participants in such proceedings have the right to appeal against such rulings, which to date they have not done. Thank you very much.
Thank you very much, Kyrgyzstan. So now the United States of America, followed by Serbia. The floor is yours.
Thank you, moderator. With respect to some of the comments made by the Russian Federation, the United States fully complied with all of its international and domestic legal obligations in the apprehension, prosecution, and conviction of both Mr. Yaroshenko and Mr. Bout. Bout and Yaroshenko were not arrested because they were Russian, but because they were suspected criminals. No evidence supports the claim that Mr. Yaroshenko was beaten or tortured either during his detainment in Liberia or after his transfer to the United States. Yaroshenko, who speaks English, regularly sees doctors and has voiced no complaints through official channels. Yaroshenko was tried in a court of law in New York in November 2011, afforded due process, and convicted of drug offenses. Mr. Bout was convicted of conspiracy to kill U.S. officials, attempting to acquire and use anti-aircraft missiles, and of providing aid to a terrorist organization, the Revolutionary Armed Forces of Colombia. In April 2012, he was sentenced to 25 years imprisonment and is currently in the U.S. Penitentiary in Marion, Illinois. His appeal was denied in 2013. Regarding allegations concerning Guantanamo Bay, we have addressed those this morning in our right of reply. Finally, regarding the origins of the conflict in Ukraine, Russian President Putin acknowledged in 2014 that Russian, quote, service members, unquote, quote, in green uniform, unquote, were present in Crimea to create the conditions for the so-called referendum. That referendum, as we always state, was illegitimate, and we rejected its results. Thank you very much, Mr. Moderator.
Thank you. So now the delegation of Serbia, followed by the delegation of Latvia. Serbia, you have the floor.
Thank you, Madam Chair. Regarding remarks made delegation on the Bitici brothers case, we would like to underline that the Republic of Serbia is fully committed to solving this case and bringing all those responsible to justice. Thank you.
Thank you. So now we have the delegation of Latvia, followed by the delegation of the Czech Republic. Latvia, you have the floor.
Thank you, Madam Moderator. I would like to respond to the statement made by the Institute of Latvian Studies. Firstly, I will refrain from commenting on mentioned individual case. By doing so, I would violate the right of privacy of the particular person. Secondly, there are no reports of politically motivated persecution made by government or its agents in my country. Such accusations are unfounded. Needless to say that investigations are handled in accordance with the rule of law and procedures prescribed by law. Only the deeds and actions of the person concerned are reviewed and investigated, regardless of his or her political belonging, ethnicity, legal status, or any other irrelevant to the law characteristics. Last but not least, please allow me to correct some data that were misrepresented, I believe, on purpose. According to my data, 26% of Latvian population belonging to Russian minority belongs to Russian minority, and 63% of them are Latvian citizens. I thank you.
Thank you. So now we have the Czech Republic, followed by the Russian Federation. The Czech Republic, you have the floor.
Thank you, Madam Moderator. Since the Czech Republic has been mentioned in this session, I would like to exercise the right to reply. I would like to briefly mention 3 points. First, on the detention in the Philippines. The two persons mentioned in the statements have been kept in a detention facility in the Philippines for breaching the rules of the Republic of the Philippines. All decisions concerning the detention are autonomous decisions made by the government of the Philippines. Second, on the consular help provided by the Czech Republic. You can be assured that the Czech Republic is in touch with both persons mentioned in the statement, and we have repeatedly offered our consular help. Third, on the court proceedings in the Czech Republic. The case is pending before a court. The independence of judiciary and the right to a fair trial is safeguarded by the Czech Constitution and is in line with our international obligations and our OSCE commitments. And as I am having the floor, I would like to use this opportunity to thank the introducer for his presentation and interesting highlights in a number of important issues. Thank you.
Thank you very much. So now the Russian Federation, followed by Ukraine. The Russian Federation, yours.
Madam Moderator, thank you. Having the right of reply, I would like to respond to statements made by a number of participating states who have said unfounded things about the Russian Federation. Now, the prisoners who are supposedly political in the Russian Federation have in fact been sentenced on the basis of legislation that is fully in line with international standards. They have the right to complain about their detention conditions. They have the right to appeal, and they take advantage of that. The Constitutional Court of the Russian Federation has decided that it will not implement, or that there is not a need to implement certain decisions of the European Court of Human Rights when that is in violation of constitutionally guaranteed principles. Now, insofar as the inclusion of Crimea within the territory of the Russian Federation, that was, as we've said on a number of occasions, the result of a freely expressed wish of the peace-loving citizens and inhabitants of Crimea. Thank you.
Thank you. So now we have Ukraine, followed by Armenia. Ukraine, the floor is yours.
Большое спасибо, госпожа председательствующая.
Thank you very much indeed. Allow me to respond to the Ukrainian delegation, whose ranks also include Judge Krapichenko. They raised points which will be closely looked at. Unfortunately, that's not something that applies to the representative of the Russian Federation. The legal system, the court system, though, the court system there, as we know, is subject to great from the executive powers. Such a system cannot be considered independent, and that's something that the international community needs to recognize in considering the protection of citizens' rights. We will never recognize the annexation of Crimea as legal. As we know, it was annexed with the use of military force. Allow me, ladies and gentlemen, to say that Ukraine, especially recently, has been taking these steps to bring its legal system into line with the standards of the Council of Europe, the Venice Commission, and the changes have been made to the Constitution relating to the term of offices of judges and the guarantees attached to that. That's something that has been part of the reform process, which has also included a complaint system to protect rights of individuals, and also the improvement of access to justice, the elimination of political involvement in questions of judges' appointment and renewal. This is now done by the by a council which, to its most part, is made up of judges. We believe that the Ukraine is moving in the right direction, and we welcome such tasks being carried out. In closing, and this is not really a part of right of reply, but I think it would be appropriate to propose to the OSCE to carry out a comparative study of the independence of judicial systems and consider that at our next annual meeting. Thank you very much indeed.
Thank you. So we have additional rights of reply. Next is Armenia, followed by Azerbaijan. Armenia, you have the floor.
Madam Moderator, I thank the representatives of Armenian NGOs for raising the number of issues. They referred to the ongoing trial of the members of the armed group, which back in 2016 violently attacked Erebuni police station. I would like to recall that the deplorable action of the armed group led to killing of 3 policemen and injuring others. The standoff lasted for several weeks, with number of police officers and civilians, including medical staff, being kept hostage by the armed group. Therefore, with all due respect, we have to reject the accusation that the trial is politically motivated. Some individuals, including mentioned Andreas Gukasyan, abused the right to peaceful assembly and called upon the protesters to disobey the police and directed them to the site of the crime, the police station. They crossed the police and with the aim to create obstacles to the police activities aimed at releasing the hostages. The police and other law enforcement agencies showed exemplary restraint in handling the situation and resolved it by avoiding any further casualties. Even in the challenging environment which some of our NGOs defined here as armed rebellion, the police generally managed to ensure freedom of assembly while also protecting rule and order. The responsibility and restraint in the activities of police were acknowledged by our international partners, including in the OSCE. We are not in position to comment the details of the ongoing trial or interfere into the judicial process. I will limit myself with one remark only. The ongoing trial is taking place in line with the legislation of the Republic of Armenia and its international commitments in the atmosphere of transparency with engagement of civil society and media. Thank you very much.
Thank you. Now we have Azerbaijan, followed by Estonia on behalf of the European Union. Azerbaijan, you have the floor.
Thank you, Madam Moderator. My delegation raised a point of order during the intervention by the NGO from Azerbaijan, but regrettably it was ignored. Firstly, the appointment to which our distinguished NGO representative has referred to in his intervention followed important constitutional changes made after a referendum which was legal and legitimate and was organized in accordance with the national legislation and the constitution of Azerbaijan. As for the appointment itself, it was done solely based on the merits, as Ms. Mehriban Aliyeva has been an active member of parliament since 2005 and head of the Heydar Aliyev Foundation. Her activities, contacts, and tremendous impact go well beyond the borders of Azerbaijan. And to conclude, while we do support the freedom of speech and expression, we find it regretful that at times these freedoms are misused by so-called experts from civil society to turn an influential international fora such as this one into chats that have no factual basis nor proof whatsoever. And finally, with regards to the intervention by the US delegate, we would like to reiterate that there are no prisoners in Azerbaijan. People mentioned in the statement have been arrested for committing certain crime offenses. Thank you, Madam Moderator.
Thank you. And just to reassure you, we were utterly unaware and none of the team realized that there was a point of order being raised. So our apologies for any confusion. So we have the final rights of reply, Estonia on behalf of the European Union, and lastly Canada. Estonia, you have the floor.
Thank you. I wish to refer to the assertion by the representative of the Russian Federation whereby the inclusion of Crimea in the Russian Federation is the result of a referendum. The European Union reiterates our strong condemnation of the illegal annexation of Crimea and Sevastopol to the Russian Federation, an annexation which the European Union will not recognize. Thank you.
Thank you. And now the final right to reply. Canada, the floor is yours.
Thank you, Madam Moderator. Very briefly, as my European colleague has just said, we have reiterated in many sessions, Canada does not or will not recognize the illegal annexation of Crimea and Sevastopol by the Russian Federation. Additionally, as was noted, we impart no legitimacy to the supposed referendum on that decision. Thank you.
Thank you very much. So this concludes the different presentations from speakers, from rights to reply. Thank you all very much for a very rich range and breadth of perspectives on this very important topic. I think we have just enough time to hand back to our introducer for a few final comments before wrapping up.
Well, thank you, Madam Moderator, ladies and gentlemen. It has truly been a pleasure listening to these interventions, all these interventions, to the discussions, as you said, Madam Moderator, on this very important topic. I, for myself, I say they fall into three parts, these interventions. You have those interventions involving alleged injustice in individual cases. Another one is, or are the interventions addressing more systemic shortcomings with regard to the rule of law and to the protection of human rights. But there is also a third category, which is, I would call them attempts to remedy the shortcomings. We have also heard interventions on efforts trying to remedy shortcomings in the judicial system and with regard to the rule of law. I think there are two main components here. We have the state authorities and we have the civil society. I would say from this conference, at least this part, this session, the message to the state authorities is that upholding the rule of law is a common responsibility for all three powers of state. So it is a common responsibility for all three powers of state to uphold the rule of law. And while doing so, all three powers of state must respect each other's domains. There are boundaries that none of us, not the courts, not the executive, not the legislative, should transcend. So, common responsibility, but act out of respect for the other's domains. That's the one message I will say to sum up from this part of the conference. The other one, the other message goes to the civil society, because when state authorities fail to comply with these rule of law requirements, when state authorities fails, as they do, as we have heard, it is so important public watchdog function of the social, of the civil society, of the medias, of the NGOs. This public watchdog function is so crucial, it's so essential. And that's when I say keep on marching, it is not necessarily meant literally, no? But rather in more general addressing the need for the civil society engagement for the protection of the rule of law and human rights. So this is so important, and I mean 50,000 people marching in July in Warsaw and in 100 other cities in Poland has an effect. You know? It has an effect. So, to the state authorities, you have a common responsibility to uphold the rule of law and human rights, and to the civil society, keep on marching. Thank you.
Thank you very much. And I think this was an incredibly important topic, and that we had a very genuine exchange of different views during this session. And that's very much what HDIM is about. So thank you all for your contributions to that. Particular thanks to our introducer and to the interpreters for the great job they always do. And I have a reminder for you all. On a very practical note, please leave your headsets. On a more exciting note, we have 4 very interesting looking side events, all very much on rule of law topics between now and the most exciting event of the evening, which is the audio reception at 8. And the bus will depart Gate 1 at 7:45, 17:45, if you would like to take advantage of 19:45, 7:45 p.m., if you would like to take advantage of the transport to that reception. Please also don't forget the invitations, which would be in your delegation pigeonholes or are available from the documentation desk. Thank you all very much for your contributions. Thank you.